The National Disability Insurance Scheme, or NDIS for short, is a Commonwealth-run, no-fault disability insurance scheme governed by the National Disability Insurance Scheme Act 2013. The NDIS is intended to be a catch-all scheme that applies in cases where the more specialised state-based schemes don't. As a result of this, the NDIS has the widest scope of eligibility amongst the disability insurance schemes currently available to Queensland residents. At present, the NDIS is being gradually rolled out throughout Queensland and will be completed by January 2019. In order to participate in the NDIS, a person must meet the following criteria listed under Section 21 of the Act. These are the age criteria, the residence criteria, and either the disability or the early intervention criteria. The first two criteria are relatively simple. To meet the age criteria, an applicant must be under the age of 65. To meet the residence criteria, an applicant must reside in Australia and must either be an Australian citizen, the holder of a permanent visa, or a special category visa holder who is a protected SCV holder. The disability requirements are set out under Section 24 of the Act. In broad terms, the person must have a permanent impairment and as a result have a substantially reduced functional capacity to undertake prescribed activities. These activities are communication, social interaction, learning, mobility, self-care and self-management. The National Disability Insurance Scheme Becoming a Participant Rules of 2013 have outlined certain circumstances where an individual will be considered to have a substantially reduced functional capacity. Under these rules, a person has a substantially reduced functional capacity to engage with an activity if they are unable to do so at all or are only able to do so with the assistance of technology or another person. The term substantially reduced functional capacity has also been considered in case law. In Mulligan and the NDIA, a physically impaired applicant suffered from a number of medical conditions that required the installation of handrails and shower grab rails in his house. When originally deciding this case, the Administrative Appeals Tribunal considered that these were items commonly used by many people, and on that basis found that the applicant did not have a substantially reduced functional capacity. The Federal Court overruled this decision, finding that this was not a disqualifying factor. The Federal Court also held that the concept of substantially reduced functional capacity did not require any assessment of how common the reduction in functional capacity was within the broader community.
Under the NDIS, once a person is accepted as a participant, it falls upon the CEO to see to the preparation of a participant plan for that individual. The participant plans for each person have to be individualised and they have to be, as it's described, participant directed. That is to say that the participant has significant input and influence with respect to the content of the plan. Two particular things that the participant plan must address. The participant plan must include a statement about the individual themselves, addressing things such as the person's context, that is, their environment, their living conditions, and it must also address their goals, what their aspirations are, what they would like to achieve. Secondly then, the participant plan must identify the supports that are going to be provided. Those supports may be expressed as general supports, or they may be expressed with more precision. And those two things are not silos, they are in fact required to be linked. In a decision earlier this year, the Federal Court had occasion to rule upon a dispute between the National Disability Insurance Agency and a Mr McGarrigle, who was a participant under the NDIS. The particular context for this dispute concerned funding for taxi travel. The issue that arose involved the question as to whether or not the level of funding to be provided could be reduced because of the agency's assessment that there were other resources available to Mr McGarrigle that would allow for him to have his needs with respect to travel met other than by full funding by the agency. In particular in that context, whether the availability to him from time to time of members of family, for instance, to assist with travel meant that the funding could be reduced, in this instance, to 75% of that which might have otherwise been needed. The ruling of the Federal Court, Justice Mortimer, was that once, in fact, the agency had assessed there as being a support that was reasonable and necessary, then it was incumbent on the agency to fund that support in full.
While the NDIS covers supports relating to a person's ongoing functional impairment, it does not cover clinical treatment of a health condition. This is so even where there is presently no funding available under the general health system or other schemes. In the AAT case of FEAR and National Disability Insurance Agency, the participant had suffered a catastrophic brain injury and was being cared for by his family at home. His parents had requested equipment to measure his oxygen levels at home and oral suctioning equipment, on the basis that this would ensure the participant could continue to receive care at home as opposed to a hospital or another facility. While there was no dispute that the participant needed this equipment, the tribunal found that those items related more closely to treatment of the participant's health needs and was therefore more appropriately funded by the general health system. People who have already obtained compensation for their injuries may still be able to claim support under the NDIS in the future. However, any funds they receive will be reduced to ensure there is no duplication of funding for supports. Specific rules have been made about how compensation is taken into account, which are outlined in the Accounting for Compensation rules. This involves calculating a compensation reduction amount. In the case of judgments or settlements where the NDIS component of the compensation is identifiable, for example where different heads of damage have been specified, then that calculation will be fairly straightforward. However, where the NDIS component is not identifiable, the calculation of the CRA will depend on a number of factors, including the amount of the settlement or award under a judgment, refunds to Medicare or Centrelink, amounts paid by the participant for support since the time of judgment or settlement, and amounts paid previously under the NDIS to the participant. The compensation rules also apply where a person has agreed to give up their right to compensation in respect of an injury, and the CEO of the agency is not satisfied that it was reasonable for the person to have entered into the agreement. There are a broad range of matters which the CEO must take into account in considering whether a person's entry into an agreement was reasonable. Interestingly, under the compensation rules, the CEO may ignore the compensation reduction amount in its entirety or in part if the CEO thinks it's appropriate to do so in special circumstances, including financial hardship. It remains to be seen how that discretion will be exercised. Where a participant already in the scheme receives compensation, the participant will be required to repay any amounts previously paid under the NDIS in respect of the participant's impairment caused by the compensable injury. Where an award has been reduced due to the participant's contributory negligence, the repayment will also be reduced by the same proportion. That also applies in respect of settlements or consent orders, and so it will be important to specify in the terms of the settlement or order if there has been a reduction in the settlement sum on account of contributory negligence.
Sections 104 and 105 of the Commonwealth Act empower the CEO to compel a participant or would-be participant to pursue a claim for compensation or for damages, and indeed even empower the CEO to take over the conduct of such a claim or to initiate such a claim